Good morning. Thanks to everyone who joined us today for our Show Me the Money webinar, during which our speakers will present on the current legal landscape for employee compensation in Ontario's public sector. I'm Laurie Turner, and I'm the co-leader of Fasken's Health Law Group. And while our speakers today are members of Fasken's Labor, Employment, and Human Rights Group, they are also members of our broader Health Law Group. This webinar is of relevance to many in the sector that our Health Law Group serves, including, for example, public hospitals. On our panel today are three members of our Labor and Employment Group. And by way of very brief introduction, first we have Erin Porter. Erin is a partner in that group, and she has considerable experience working in-house for one of Canada's largest retirement and long-term care home providers. Erin's practice is focused on advising and representing employers in the labor, employment, and human rights matters. And next, we have Lennie Lejasisaks, practicing labor, employment, and human rights law. He advises unionized and non-unionized employers across private and public sector. He also provides strategic advice and representation to employers in all matters arising out of the workplace. And last but not least, we have Jacob Wagner. Jacob is an associate in our firm's labor and employment group. He maintains a broad labor and employment practice and represents both unionized and non-unionized employers. One final matter for housekeeping. We'll welcome questions from our audience today, and we will do our best to answer them, as many of them as possible at the end of today's presentation. Thanks very much.
Hi, everyone. So thanks for joining us this morning. Our usual lunchtime sessions have been moved to the early hours, so hopefully everybody has their coffee in hand and is ready to spend an exciting hour talking about compensation in the public sector. We'll start first, if we can go to the first slide, we'll take a look at our agenda for what we're going to speak about today. We'll begin with Bill 124, and as you see, going, but is it gone? So we'll discuss the status of Bill 124 and what employers should know about that legislation. We'll then move on to the broader Public Sector Executive Compensation Act, where Lennie will take you through that legislation and remind you of some of the obligations that still exist within it. And then finally, are you walking on sunshine? We'll talk about, insert music here. We're not allowed to play the music, but you can sing along in your head. We'll talk about the Public Sector Salary Disclosure Act. You'll notice one theme for all of the pieces of legislation, that they have very long titles that you are bound to forget one word within them. So we'll often be referring to them just by simplified names. And with that, we'll start with Bill 124. So Bill 124. Before we begin, we'll remind you about where we were and how this all started. So on November 8th of 2019, the Ontario Legislature passed Bill 124, or the Protecting a Sustainable Public Sector for Future Generations Act. Bill 124 applied to hospitals, Crown agencies, school boards, some universities, children's aid societies, and generally organizations that were carrying on not-for-profit that had received at least $1 million in funding from the government in 2018. The legislation imposed 3-year moderation periods, and during that time, the increases to salary and compensation were reduced or limited to 1%. So you could only have a 1% increase in terms of your total compensation package. The moderation periods started at various times. It could have been any time between June 5th of 2019, and then the last moderation period was set to start January 1st of 2022. And when organizations decided to start that would depend on when collective agreements expired or other considerations for their non-unionized employees. Of course, you're probably all familiar with the various exceptions under the legislation. So there are limited exceptions that would allow you to increase salary and compensation beyond 1%. And so that was if it was already provided for either in a compensation plan or the terms of your collective agreement, where an employee's length of time in the position would allow for increase, so essentially progression along a wage grid. If there was an assessment of performance, so if you had an established practice of increasing people's salaries based on performance indicators. So for example, if you had an above average or exceeds expectation performance review, then maybe your organization had tied increases to compensation to that. And then finally, if employees were successful in the completion of a program or course of studies. So those were limited exceptions that didn't really allow for many opportunities for employers to increase beyond the 1% cap. And if they did, then the government could make a ruling or determination that the increases were inconsistent. I'm not aware of any reported decisions or awards where the government actually would impose findings like this, but I do know that there were some organizations that wrote to the minister to see if they could meet within one of the exceptions or if their program could be approved. And those requests in some cases were met with denials. So beyond that, that's an overview of Bill 124, just to remind you of what it is that we're talking about. And I'll pass it over to Jake, who will discuss where we are now.
Thanks, Erin. So if we could go to the next slide, we'll see that, with all contentious legislation, there happens to either be a constitutional challenge or a charter challenge, and that's no different here. And this came by way of the Ontario English Catholic Teachers Association and His Majesty. And on November 29th, 2022, Justice Conan delivered his decision on this court challenge, saying that the legislation did in fact infringe on the applicant's rights to freedom of association and collective bargaining. And this legislation was also not saved, which the government bears the onus to show under Section 1. Writing for the court, I think it's important to mention that Justice Conan stated, the Charter protects not just the right to associate, but also the right to a meaningful process in which unions can put on the table those issues that are a concern to workers and to have them discussed in good faith. I'd like to also mention that Justice Conan did hear arguments and dismiss those arguments that the legislation infringed Section 2B, the Charter right for freedom of speech, and Section 15, equality rights. Just spending a little bit of time on the analysis of the Section 1, where the government has the onus to demonstrate its applicability. There are four arms to the test. The first is, does the legislation have a pressing and substantial measure? Second, does the legislation have a rational connection to what it's trying to achieve? Third, does the legislation minimally impair the charter right? And finally, do the benefits of the legislation outweigh the deleterious effects of the legislation and infringing that charter right? And I'd just like to touch on a few points that Justice Conan opined on in his decision. Under the first arm, whether the legislation is pressing and substantial, he did note that managing public resources and sustaining public services could be or could amount to a pressing and substantial objective. However, the evidence that was brought to him in this decision showed that the economic conditions in 2019 were not sufficiently critical of nature to warrant infringing a constitutionally protected right. So while it could be pressing and substantial, just on the evidence of what was occurring in the landscape, there were no evidence in front of Justice Conan and in his view that would warrant this infringement. And then he went on to then do the rest of the test, although the test could have finished. Whether there was a rational connection between the legislation or not, Justice Conan again wrote that while moderating the rate of compensation is logically related to the responsible management of the province's finances, the concerns of wages and goes beyond what the act was. The act was far more widespread and wide-ranging just wages. And so for that reason, he found that the rational connection may not actually be there. Under minimally impairment, it was interesting that Justice Conan really discussed that this legislation was one of political convenience and expedience. And in his view, to refuse the funding really doesn't justify the infringement, that it's just the easy way to do it. And that's not really the test, because if that was the test, politicians and governments would just use political expedience to just say this is the easy way and then this is the best way to do it. So that's not really minimally impairing the charter right. And then finally, when doing the weighing between the benefits of the legislation and the negative impacts on the charter rights, Justice Conan kind of opined that, had Ontario taken a hardline approach through the collective bargaining process, wage restraint would have come up in the discussions, obviously, and they could have had, discussions at the table, or this could have involved a series of strikes, but all of these would play out in the public opinion. And that to him is that this fight should have played out in that court of public opinion. And that to him is the cornerstone of a free and democratic society. And I'd just like to read just one piece, if I may, where he wrote at paragraph 353, if governments are permitted to infringe on charter rights in times of relative growth and prosperity, in the absence of any present or imminent fiscal urgency without explaining the need to breach charter rights or the need to pursue inconsistent policies, it would be far too easy for governments to infringe on charter rights merely by asserting the need for fiscal prudence. And I think for Justice Conan in this decision, the legislation was just too far reaching, and that there were other measures that could have been looked at that would have infringed charter rights a lot less. And again, just the broad scope of the legislation, it just went too far. And so if we move to the next slide, where does that leave us? I guess we're moving on to filing for a stay. If we go to the next slide. Yeah, thank you. So arbitrators here are really saying that, reopeners are open for business. Although Bill 124 was struck down, there really was no stay sought. And so if the government had applied for a stay, there might be a different question or a different analysis, but arbitrators think it would be prejudicial to have to wait for the appellate process to bear out. And, many arbitrators have started to jump on this bandwagon. And arbitrator Kaplan was the first to start this trend. If we could move to the next slide. So under Orange and Unifor, arbitrator Kaplan originally wrote in his consent award that in the event Bill 124 was repealed, amended, or rendered inoperative, up to 5 years from the date of ratification and arbitration, the parties agree that the wages will be included in retroactive adjustments. And I think rendered inoperative is an important piece in this consent award. The union came back before arbitrator Kaplan and really stated that, since the legislation has been struck down, the legislation is rendered inoperative, and we're able to have these discussions and open, these discussions again. The employer said, hold on a minute. The appeal is still ongoing, and the court has yet to make up its mind. And so in order to await final judgment, this is just too early. It's too early to start these conversations. The employer also offered in this case that it would pay any interest on payments should the government's appeal be unsuccessful. And finally, the employer's last position was that it would not be good for labor relations if the employer had to eventually claw back payments if the government was successful in their appeal process. It would be highly difficult for them to do so. And so on the next slide, arbitrator Kaplan was not swayed by the employer's arguments, unfortunately. In his view, Bill 124 was rendered inoperative. The fact that there was no stay or applied stay by the government and it wasn't granted, really in his view, allowed him to decide on the matters, and the wage reopener, could move forward. And the kicker in this decision was that arbitrator Kaplan noted that the employer could recoup any overpayment if required and if the government was successful. He didn't mention how that would happen or the logistics of that, and we all know that would be highly difficult to do so, but he offered that in his decision. And so moving on to another interesting decision from Mi Xiang, Richmond Hill Long-Term Care Center and Service Employees International Union. Here in this original decision in August of 2022, the board awarded a collective agreement which covered the period of January 1st, 2021 to December 31st, 2022. And this was during the moderation periods. In the original award, they stated a kind of wide-ranging reopener clause in their view, which stated that they would remain seized with respect to compensation should the constitutional challenge brought to Bill 124 be successful, and the union be granted an exemption from the legislation, or should the legislation be amended in respect to compensation. Now, when the employer came back in front of the board, the essence of their argument was that the board was functus officio, that they had issued their final decision regarding the collective agreement, and that they had fully discharged their function over the matters, and that they had no legal authority anymore. And the employer relied on Section 9, Sub 2 of HILDA, which states the Board of Arbitration shall remain seized of and may deal with all matters in dispute between the parties until a collective agreement is in effect between the parties. And interestingly, they submitted that, since the collective agreement is in effect between the parties, and they've executed one, there really is nothing to see here anymore. And the board has really discharged their whole duties over this matter. And so that argument was very nuanced, and the board didn't buy it. They found that the submission, just because they did not put a reopener clause into their original decision doesn't mean that wasn't the intention, and that the intention wasn't crystal clear. And they kind of called out the employer here for a highly technical objection. And there really was no merit to this objection. And maybe this defense would work, if there wasn't any language surrounding Bill 124. But here in this award, the board really relied on the fact that they could look at Bill 124, had anything been changed or amended, and would be seized. And so ultimately, the employer's objection was dismissed. And now moving on to the final decision I'll talk about today, Participating Hospitals and Ontario Nurses Association. Arbitrator Stout here follows Arbitrator Kaplan's lead. And I just want to read one of the passages, if I might, from that decision. Quoting Arbitrator Kaplan, Arbitrator Stout states that, indicating that any objective balancing of interests favors the employees who should not have to await the eventual judgment of the courts. And I think that's an important piece here, is that if there is no stay, then the long, arduous period of going through appeal process from the Ontario Court of Appeal all the way up to possibly the Supreme Court, if leave is granted, would be many, many years in the making. And so where would employees be left? And so the trend between arbitrators here is that, since there's no stay, there's really no problem, and they can act in their capacity. I know this decision has other trends regarding wage reopener and benefits, and we'll touch on that a little bit later. And finally, the making of a stay here, and if we can just go back to the stay slide, there's an ability here where there's an automatic stay or a stay by order. Under the rules of civil procedure, Rule 6301, there are certain types of provisions in that where you can, have an automatic stay. And that would be orders for payment of money, such as spousal support or child support, or it could be an order to have a person leave their residence under the Residential Tenancies Act. However, under this legislation and under the rules of civil procedure, really, there's no automatic stay in this instance. So the government would have had to apply for a stay, and that would be under Rule 6302. And while the court, doesn't have to have a time limit for that, there are some prejudicial effects if you don't apply for a stay the moment that you seek appeal, because that stay test is very, very similar to that of an injunction, where irrevocability is one of the main pillars. And so it would be very hard for a party on that motion to try and argue irrevocability months and months after the fact. And so, not saying that it would be unsuccessful here, and we don't know, and the government still could file a stay order, but we do know that it would be a tough battle and an uphill climb to try and get one. And with that, I would just like to pass it along to Erin to talk about trends in awards.
Thanks, Jake. So what are we seeing now? The first thing, and I think Jake alluded to this, is that generally we're seeing arbitrators are taking jurisdiction. So many of you may have reopener clauses or even just broad language, either in your interest arbitration awards or in your settled agreements, that indicate that if Bill 124 were overturned, that you would go back to the table to talk about wages. And so we haven't seen any decisions yet that would say that the arbitrators aren't taking jurisdiction. And so I think you can probably expect that if the union is asking to consider the reopener, then you're going to have to at least engage in those discussions. We're also seeing that the trend for the reopener is about 3%. It may be a little bit lower than that, but it's around the 3% per year. So, typically it would be an increase of 2% because the 1% awards would have been given. And what I find really interesting about this is that if you look back at the collective bargaining data for that period of time, so the periods of moderation between 2019 to 2021, you really do see wages within the private sector, so industries that wouldn't have been impacted by Bill 124. The wage increases were around 1.7% on average. And if you look at specific industries, maybe like manufacturing or construction, there might be some increases that were a bit higher, maybe in around the 2% range, but you don't see awards at that period of time that were in the 3% range. And so what seems to be happening is that arbitrators are looking back and with a lens from today saying, well, inflation is up. The healthcare industry in particular was hit very hard during COVID, and their workers we're working extraordinary hours, and there is a difficulty in retaining workers because of the pandemic. And so they're awarding 3%, I think, based in part, at least, on that, rather than, thinking back to the principles of Hilda about replication. What would parties have been able to bargain themselves if they had naturally bargained during that period of time? And so, I think that that's certainly something that we're seeing and something that's of note. And then the same thing is true as well for the benefit piece, where you're seeing these awards, such as the ONA Central Award for the hospitals, that award things like unlimited mental health benefits. And these are benefits that in today's bargaining context, you're certainly seeing more of. But if you look back to, again, the period that this is supposed to be covering, so the moderation periods, it wasn't as common. And so it's unlikely that the parties, if they were naturally left to their own bargaining, would have been able to achieve awards like this, such as unlimited mental health benefits, again, which is in the ONA Participating Hospital Award. So that's one of the things that we've really noticed, and one of the things that we've had a lot of discussions about here in our office. We're also noticing that many employers with their non-unionized employees are welcoming the opportunity to increase wages, because again, there has been such a challenge with retention. And I know that many employers were struggling trying to compete with other industries or with the private sector when they were restrained to this 1% wage increase year over year. So I think that many employers are seeing this as a welcome change, that the legislation has been, at least for now, struck down pending appeal. The last thing we've been talking a lot about is what's the impact of things like pandemic pay. And again, so you look at certain industries and they were awarded $2 or $3 an hour and now $4 an hour on top of their regular wages. And you wonder if that same payment would have been made if Bill 124 hadn't been around, and now is it just a compounding of benefits that employees were provided with the pandemic pay, and now are also getting retroactive pay of about 3% or retroactive pay of 2% if they already received the 1% increase. So is it really just a pyramiding of benefits, and are arbitrators actually considering all of the different levels of pay that have been out there and that employees may have received? Now, again, employers may not be as fussed about this as they would have in the past because there's such a difficulty in retaining talent and recruiting talent. So these are unique circumstances, I think, when you consider this in the economic context that we're in right now. And finally, if we look at the last slide in this section, going forward. So first of all, has there been any word from our premier? And so far, other than when the decision was first released, there hasn't been really any update from Premier Ford. At the time of the decision, he did spend a significant amount of time arguing that the legislation actually doesn't exist anymore. And he said that the legislation had lapsed. And presumably that's because of the moderation periods. And he was thinking that even for those who were sort of saved it until the very end of the legislation, they would be nearing the end of their moderation period. And perhaps that's why the government didn't seek a stay of the legislation at that time. Or perhaps the political climate has also changed, and Premier Ford was recognizing the difficulties that many public sector employers were having in terms of retaining and attracting talent. And then finally, the appeal has been scheduled to be heard by the court between June 20th and June 22nd of this year, which is actually sooner than I would have anticipated. And typically it will take a couple of months for the decision to come out. So we should see a decision on this appeal by the early fall. I'll now pass it over to Lennie, who will talk about the broader Public Sector Executive Compensation Act.
Thank you, Erin, and good morning, everyone. So from Bill 124, we go to some other wage restraint legislation. This legislation, of course, targets executives in the broader public sector. And I just want to start with a brief history of executive compensation wage restraint legislation here in Ontario, just in the recent past. So wage restraint on executives in the broader public sector is nothing new. So 2010, we have some wage restraint legislation passed. And this is the Broader Public Sector Accountability Act, or the BPSAA. And so we're in acronym city now with a lot of this legislation and the different frameworks. But for those of you in the public sector, you'll be very familiar with this legislation because there's many aspects of this legislation that still apply, even though the wage restraint aspect is long gone. We have things like the procurement directive and the perquisite directive that apply to the broader public sector. And so I'm actually going to be touching on the perquisite aspect of this legislation, just as a brief update at the end of my section here to refresh everybody on it. So again, 2010, the BPSAA imposes a wage freeze on executives in the broader public sector. And so if we go to the next slide, we have in 2014, the Broader Public Sector Executive Compensation Act being implemented. And this is, the acronym here is the BPSECA. Now, the wage freeze from 2010 under the previous legislation carries forward under Part 2.1 of that legislation. Now, what this legislation did when it was first implemented is it gave the government the ability to implement what it was calling compensation frameworks under the legislation. Now, no compensation framework was actually passed until June of 2017 under this legislation. So for the intervening 7 years, the previous legislation imposed the wage freeze and especially a freeze as well on performance-related compensation. However, in June 2017, we have the government implementing what it called the Executive Compensation Framework, and then that was passed through a regulation to this legislation. Now, what that did was actually create quite a complicated scheme where the employer was required to create a compensation plan that was both inward and outward looking, so market looking, which was actually relatively new idea in the public sector, right? Let's compare other organizations, see how we match up and make sure we're competitive in the market. And so When this was implemented, many organizations jumped on it right away, of course, because executive compensation had been frozen by this point for quite a while. And this required quite a process of comparators, and then the organization had to post it on their website or make it publicly available for comment. And then, through its governance, whether it's a board of directors or whatever specific governance form an organization had, it had to be approved. Now, I mention this because some organizations who jumped on this right away, did have their new compensation plans approved, and executives received likely raises under that after being frozen for a long time. Other organizations were in the process of going through their compensation plans and all the work involved in that when the new framework in August of 2018 was implemented. Now, what happened between June 2017 and August 2018? Well, if you remember, there was a provincial election. And so in June 2018, a new government was elected. And so very quickly after the new government was elected, they implemented the new compensation framework in August of 2018. Now, what it did was immediately froze salary and performance related pay for executives. And so this legislation, we're almost 5 years later now, is currently in effect. And I'll explain in just 1 second what this legislation and the compensation framework does. But what's key to note is that if an organization started on the compensation plan under the previous executive compensation framework, but didn't actually implement it, all that work was basically, put aside, and executive compensation was still frozen at the previous levels. So in other words, those executives wouldn't have been able to get a raise under the new plan. However, those organizations that did implement the new plan under the previous June 2017 regulation and framework implemented raises. And then in August 2018, those were then frozen. And that's key to mention because a lot of organizations in the broader public sector have been stuck for a long time at compensation levels that date back over a decade at this point. Next slide, please. So let me give you a brief overview of the compensation framework. As I mentioned, came into effect immediately on August 13th, 2018. This did catch a lot of organizations off guard of how quickly it was implemented. And they were, as I mentioned, working on previous compensation plans at the time. And so this is known in the compensation framework as the effective date. And I'll just mention that here because that's really the guidepost in terms of when things are frozen in time. And there's a few small, narrow exceptions to this August 13th, 2018 effective date, but those really only apply to organizations that might not have had a designated executive at the time or didn't necessarily exist at the time. So if an organization caught under the framework was started or created after this, they would have a later effective date. But for the vast majority of organizations caught by the compensation framework, their effective date is August 13th, 2018. And so there's a couple terms we need to define in the next slide, but who does this apply to? Well, it applies to designated employers. So you're going to ask, what is a designated employer? Very good question. Here's a list. So in the broader public sector, it captures most organizations. So we have public hospitals, school boards, universities and colleges, the IESO, which of course is the Independent Electricity Systems Operator, OPG, Ontario Power Generation, and Orange, our air ambulance service here in Ontario. It also captures public bodies and commissions, of which there are many of course, in the province, but just to highlight a few for people's organizations like Metrolinx, Legal Aid Ontario. Who is excluded? Well, good question. So municipalities are excluded, and that's key to note. So municipalities not caught by the broader public sector Executive Compensation Act. They're free to implement compensation raises on their own through their own governance structure, right? Council. Hydro One also not captured, and there's others, but these are the key. So look, the takeaway from this is that most BPS organizations are captured by the compensation framework. Next slide, please. So of course, who is a designated executive? Because if somebody isn't a designated executive, they won't be caught by the compensation framework. And what they would have been caught until Bill 124 was struck would be Bill 124. So in other words, if you weren't a designated executive, you would have been bucketed into Bill 124 and your compensation capped at 1%. Now, of course, if you're a designated executive under the compensation framework here, your compensation was frozen. And so when we talk about who a designated executive is, there's really two requirements under the framework. One, the first, of course, is that the person has a specific title or set of duties that indicates they're an executive. So the compensation framework says that a designated executive is somebody who is the head of the organization, regardless of position title. But of course, what comes to mind is president, CEO, executive director, anybody who's the head of the organization. It doesn't matter what their title is. And then, of course, we go down to what I'll call the C-suite executives. So VP, Chief Administrative Officer, Chief Operating Officer, CFO, CIO, or any other executive position. So the compensation framework isn't beholden to title, right? It's anybody who's an executive. Now, there's been some discussions, well, who is an executive? And the legislation doesn't define it any more narrowly than this. But, in the grand scheme of things, if somebody's reporting directly to the CEO, they're probably an executive, except for maybe an administrative or secretarial position. Anybody reporting directly to the CEO and having broad responsibilities across the organization, likely to be captured and treated as an executive in the compensation framework. And of course, the second requirement, which I really don't think comes into play for most organizations, is that they have to earn $100,000 or more. Next slide, please. So the framework does two things, right? It freezes salary, but it also freezes performance-related pay. So let's start by talking about salary. And so what the compensation framework does is create a salary cap based around what positions were paid on, and here's again, the effective date that the regulation came into play. So in other words, salaries are frozen as to what they were on August 13th, 2018. And it's not the salary band of the position, it's the salary that was being earned by the incumbent of that position. So in other words, as you'll see from my last bullet, it's not the salary range for the position. So let's just use an example. If you had a specific position, let's call it a chief operating officer position, and the salary range for that position was $250,000 to $300,000. And let's say the incumbent in that position maybe just started a year before compensation framework came into play. Let's say they were earning $250,000. Now, of course, the range for their position, it's up to $300,000. The range doesn't matter. If they were earning $250,000 as of the day the regulation came into effect, that is what the salary for that position is frozen at. It doesn't matter what the range or the band is. Next slide, please. So here's my little cheat sheet and my little chart that I like to refer to. So because there's really three scenarios that play out as it relates to salary under the compensation framework. So we ask the question, when was the position last occupied? And then that tells us what the salary cap is. So let's go through this. So if the position was last occupied on the effective date, the salary for the position is frozen as of the effective date. And that's the scenario basically we just talked about. Now, what happens if on the effective date, the position was vacant, but it was previously occupied? So the framework tells us the salary for that position is going to be frozen as of the date it was most recently occupied. So this is, and organizations need to be careful about this. So if on the effective date, the compensation framework came into effect, you had a vacant position and you hire into it, your organization can't say, well, look, we want to pay that person at the high end of the range if the previous incumbent was earning on the low end of the range. The framework says you need to pay that person what the previous incumbent was earning. So again, right, it's not about the range, it's what the previous incumbent would have earned. Now, what happens if you have a new position in your organization or you change a position, reevaluate it, right? Organizations restructure all the time. So what the framework tells us is that the salary cap for the new or changed position is going to be an amount determined by the employer's governing entity that is less than or equal to the salary cap for the most similar designated executive position in the organization. So in other words, the analysis you have to go through here is to say, well, look, if I'm making a new position, I need to do a job evaluation, and then I need to determine who the comparable position is, because that position will be only be able to be paid up to the most comparable position. And same thing with a changed position, right? If a position changes and you go through the reevaluation process, that salary is going to be capped to the most similar position. Next slide, please. So some common salary questions we get, and just given the time, I might actually leave these to the end, but I'll just mention if somebody hires a new position and if the employer hires somebody new, that answer will be in the chart, right? They're going to be capped to what the previous occupant was paid. And just on this idea of market compensation, the framework doesn't account for market compensation. The framework says your organization's salaries for executives are fixed as of the date the regulation came into effect. And you're going to say, well, the market is paying more. And that may be true, but the compensation framework, unlike the previous 2017 framework, makes no account for market pay. And then what if a position changes over time? Well, that's a good question. And I think largely that depends on, has the position sufficiently changed such that, a restructuring has occurred or significant new duties have been added, such that it becomes a new position where it may be reevaluated and compared to a higher paying similar position. Next slide, please. So just a few notes quickly on performance-related pay envelope. So again, similar to salary, the compensation framework freezes performance-related pay, and it does so based on this concept of an envelope. So let's just use a round number. So if your performance-related pay envelope on the effective date was $100,000, it's going to be frozen at $100,000 moving forward, subject to new positions or positions being eliminated, and then you can prorate the envelope up or down accordingly. But in general, you're really stuck with the compensation, the PRP envelope, as of the day the compensation framework came into effect in August 2018. And the legislation says the PRP for all designated executives shall be less than or equal to the employer's PRP envelope. Next slide, please. So just as I did with the previous chart, let's just go through a couple scenarios here. So if you have a vacant position, for example, on the effective date that the regulation comes into play, you can add to the envelope a prorated amount up to the PRP dispersed for that position when it was most recently occupied. So in other words, say, for example, that executive, again, to use a round number, who occupied the position previously had a $10,000 performance-related payout during the time they occupied that position. That's what this person could earn, and that's what can be added to the envelope. So if you had a new position, same thing. You can add a prorated amount for the most compared to the most similarly designated executive position. And then if a position becomes vacant or is eliminated, you need to take that money out of the PRP envelope. So like I said, the envelope is the concept of an envelope, while it is fixed as of the effective date, it can move up or down depending on changes to positions, right? People fill them, they become vacant. Next slide, please. So restructuring, I've kind of touched on this already, but look, there are general anti-avoidance positions in the compensation framework and the legislation. An employer cannot simply alter a title or a position to circumvent the compensation framework, right? You can't just say, well, we're going to change this title and give it more money. No, that's not the intent behind the restructuring positions. The legislation says that restructuring must be carried out solely for a bona fide purpose. Now, what does that mean? Well, it's going to be unique to every organization, and it's hard to paint with a broad brush here. However, it does really need to be a legitimate restructuring. The position would need to significantly change, for example, right? And what that means in the context of your organization, you'll have to do an individual analysis. But positions do change, right? Duties are added, sometimes they're taken away, departments added. So you need to go through that analysis to say, well, has a position changed so that it can be now compared to a higher paid position, for example. Next slide, please. So the compensation framework does prohibit certain elements of compensation, and I'll just quickly go through some of these, right? We have signing bonuses, retention bonuses, cash housing allowances. You can't guarantee an executive more than 24 months notice upon termination without cause. And none of these should surprise anybody in the BPS. These are kind of also captured under certain perquisites or long been held to be prohibited. So again, you can't circumvent the legislation by paying the executive other elements of compensation. And next slide, please. So compliance and enforcement, again, it's really voluntary. Organizations can be asked to do attestation reports and audits. And if an employer has circumvented the legislation, they may be required to repay an overpayment. And the legislation actually specifies that the designated executive will owe a debt to the employer. Now, we're not aware, I have not heard about any organizations actually being audited under the compensation framework. It's largely let's call it a trust-based system. And look, boards of directors and the governing bodies of these organizations are responsible for enforcement of executive compensation, through the executive compensation committees of the board and so on and so forth. So that's really where compliance rests, although the government can audit. Next slide, please. So just in the interest of time, I know we're about 1:45. I just want to spend maybe a minute or two on perquisites. So this is back to the original legislation I was talking about and the broader public sector perquisites directive. Now, you'll get these slides after the presentation, but I just want to highlight that perks in the broader public sector remain prohibited. Now, this doesn't apply to just executives. This is all groups, but often comes up in the context of executives. So you cannot give perks to board members, elected officials in the case of school trustees, or employees, including executives. And any BPS organization must comply with the directive. Next slide, please. So just broadly, organizations have to establish rules that are in line with this directive and then enforce them. And this falls under the organization's governance framework. Next slide, please. So what's not allowed? You can't give gym memberships to people, fitness clubs, golf clubs, social clubs. One question that often comes up is, well, can an organization negotiate a discount for employees to buy a gym membership? Yes, that's okay. Like, discounted memberships where the employee is paying, that's fine. That's where an employer uses their buying power to get group memberships, but the employer can't provide those memberships. Seasons tickets, sporting events, clothing allowance, access to private health clinics, those are all big no-nos. Next slide, please. So what is allowed? Well, the directive doesn't actually apply to collective agreements. So if a union negotiates a benefit with the organization, that's exempt from the perquisite directive. Insured benefits, for example, EAP plans, pension plans, where an employer provides work boots to an employee who is in a safety sensitive position, accommodations if somebody gets a sit-stand workstation, travel expenses, meals that are legitimate under the organization's travel policy, those are also exempted. Next slide, please. So I'm going to pass it now back to Erin, and she's going to talk a little bit about the Sunshine List, walking on sunshine. Take it over, Erin.
Thanks, Lennie. So we'll just spend a few minutes talking about the Sunshine List. Nothing much has changed here, which perhaps is part of the problem. The legislation was enacted in 1996 by the former Premier Mike Harris, with the goal of being transparent and accountable to public spending. Under the legislation, of course, all public sector employers are required to report people who earn over $100,000 or more in salary. And if they do, then they have to report both salary and benefits for those people by March 31st of each year. I think it's published March 31st of each year, and actually it's due, I believe, by March 5th of each year. And it's put into a web portal. The employers will get an email, and you need to respond and reply with all that information by the deadline. What's interesting about this is that the legislation hasn't actually changed since being introduced in 1996. And when $100,000 is continues to be the cap. And if you factor in inflation, $100,000 in today's money would be about $160,000. And so it's now capturing a much larger group of the public sector than it did previously. So approximately 267,000 employees made the Sunshine List in 2022, whereas when it was first enacted in 1996, it was only 4,756 employees. So you can see that it's had extraordinary growth in terms of the list. If the employer does not disclose by the deadline each year, then funding can be withheld, and the funding will be withheld until such time as they comply with the obligations. And if you don't comply within the obligations within the fiscal year, then the funding is lost. If we look at the next slide, we can see just a little bit of statistics about it. Of course, it's released annually. It now provides 27 years of data. Just over 500,000 employees have been captured since the time that the Sunshine List was created, and it accounts for approximately $277 billion in salary. Finally, if we look at the last, believe it or not, there are cases that talk about the Sunshine List. Lawyers always love cases. So I went and did a little bit of digging. The first case that we have here is interesting because it talks about a settlement. And in the settlement, there was an agreement to keep the minutes of settlement confidential. And within the settlement, an employee received compensation as part of a severance package for 2 separate years. So, he received payments in 2 different years. And then the employer reported that, as it was required to do, on the Sunshine List in each of the following years, which led to the employee being questioned about, hey, you said you were resigning from this job. How come you're showing up on the Sunshine List as receiving, X amount of money for the year after you said that you had resigned? That doesn't seem to make sense. And not only did friends and family or other employees question that, but his new employer also questioned that, because he had told his new employer that he had left his previous employment voluntarily. And then, of course, when the new employer saw that he was on the Sunshine List, realized that perhaps he hadn't been completely transparent and honest. But the union took the employer back to arbitration, and the arbitrator said that this fell under an exception under the minutes of settlement, because the way that the deal was structured, this was considered to be earnings in each of the 2 years, and so the employer had to report that on the Sunshine List. And then the second case on here is just an example. These cases are fairly common. They come out of the Privacy Commission, where people have requested under the Freedom of Information and Act to have access to employee information pertaining to salary and benefits. In most industries, of course, this would be an exemption under the legislation because it would be considered personal private information. But because of the Sunshine List and the fact that this information already has to be publicly disclosed, it doesn't fall under the regular or normal exemptions under privacy legislation, and therefore employers are required to release it. So that's just a very high level reminding you of obligations under the Sunshine List. We did want to save a little bit of time for questions, and Laurie is going to be our moderator for that, and she will take us through some questions and comments from the audience.
Great, thank you. Okay, so the first question is, how much flexibility is there really with non-union, non-exec compensation? Is the sky the limit?
So I think, and Lennie can chime in to talk about the broader Public Executive Compensation Act, but in terms of where we are with Bill 124 now, it really is, although the legislation is under appeal, I do think that it is open to employers and unions and to negotiate wages, that would be suitable in the environment that we're in. So, with inflation today, we talked about the reopener trend being about 3%. If you look at just interest arbitration trends in general that aren't reopeners, you're probably still closer to wages in and around the 2%, maybe a little bit higher than 2% range. But so I don't know if that's the sky, but there certainly aren't the same limits, at least for those other than when you're dealing with the executives.
Yeah, and just to chime in, so on the non-union side of things, what you would need to do is an analysis of whether that group, what group buckets into where. So if they were a non-executive position, well, then the organization's free to make to do increases subject to whatever compensation philosophy you have and governance. On the executive side, the compensation framework is good law, so that was not struck down like Bill 124. And just a note to folks, Bill 124, as Jake mentioned, was struck down under 2D of the charter, which speaks to freedom of association. And of course, this executive group we're talking about, these designated executives, they're obviously a non-union group. They're exempt from being unionized under labor relations legislation. So when it comes to a charter challenge to the compensation legislation, one, we haven't seen that, but whether it would be successful or not, much less likely, because freedom to association not an issue for that group.
Well, and I think too, building on what Lennie has said, when you think about the wage reopeners, that's of course only happening in unionized contexts. So for non-union employees, they're not going back and saying, hey, can you renegotiate my salary or my performance increase from 3 years ago when we were in the moderation period. So those non-unionized employees aren't going to have the same kind of catch up from a reopener that the unionized employees might have. And so that might lead to you making different compensation decisions for your unionized versus your non-unionized groups going forward, because you may feel like you need to do a little bit more catch up with your non-union employees, depending on moderation periods and where you are in that sort of cycle.
Great. Okay. The next one is a statement, but I'm going to try to form it into a question. So how does the broader Public Sector Executive Compensation Act fit within the context of Bill 124 and the court's decision declaring Bill 124 to be unconstitutional? Lennie, is that one that you would take?
I don't know, Jake. Why don't you take a shot at that?
I guess I would just say that they kind of mirror each other. So one would be, the public sector with unions, and the other one's a broader compensation, which is for executives, which would be non-union. So I think they kind of mirror each other in a way. And as Lennie had alluded to, Bill 124 was under Section 2D of the Charter, right? So that's association to bargain, which is very different than the Compensation Act. So I think it's just a broader picture of, you have folks that are unionized in your organization in the public sector, but then you also have executives, and everyone's kind of playing in the sandbox together. And so that's how I'd couch the two together.
And I think too that the broader Public Sector Executive Compensation Act is still very much alive and well, or at least alive. I don't know if it's well, but so it still will apply. And because we are not, the executives are not captured by unions, it's unlikely that it would be subject to the same sort of charter challenge, because you can't sort of hang your hat on a constitutional challenge around the right to freedom of association under Section 2D. So although there used to be interplay, as Lennie was talking about, where if you weren't captured by the broader Public Sector Executive Compensation Act, then you were captured by Bill 124, that no longer exists, again, subject to appeal. But where we stand right now, it's only the Executive Compensation Act that is likely to, or that is still in full force.
Great. The next question is, what needs to happen to generate a change from 100,000 to a higher amount for the purposes of the Public Sector Salary Disclosure Act?
I mean, we can lobby the government, I suppose, to try and get them to increase the limit, which I think, it certainly makes sense. I haven't heard of any sort of initiative on the government's part to look for consultation on the legislation, but I do think, given the fact that it's been in place for almost 25 years, I think it's probably appropriate to increase the amount for disclosure. And I've seen some articles and some thought pieces on the Sunshine List that suggest that it would be appropriate to go up to $200,000 now. So, write your MPs, or I guess your MPPs, and let them know that you think that the salary limit should be increased, or work on ways to position yourself with the Ontario government to try and get that rectified.
Okay, and I think we have time for one last question. Would nonprofit, non-unionized organizations like a community care or a small hospice be under the BPSECA, where 60% of their funding would be coming from the province and 40% from donations?
Yeah, I can jump in and handle that one quickly. That's a really good question. It's hard to give a firm yes or no without finding out more about the organization itself. Really, it would come down to whether it was a body, like the legislation says, every body prescribed as a public body under the Public Service of Ontario Act. And so we'd really have to look at the organization and see if it qualifies as one of those bodies under the Act to see whether it would be considered a designated employer or not. So good question, but hard to answer without more details.
Great. Okay. Well, it is 10 o'clock. Thank you very much to everyone who was able to attend today's session. And thank you very much to our speakers. Please note that a follow-up email will be sent in the next few days, which will include a copy of the presentation and a copy of the video recording of today's webinar. And finally, we're really interested in hearing your feedback on our webinars and welcome you to complete the event survey that will be located at the bottom of the video player. Thanks very much.